Hello everyone, this is Naidu from Techno Legal Forum. Last class we have covered up to section 15 of Personal Data Protection Act DPDP. Today we are going to continue from section 16. Okay, section 16 to section 23 will come under chapter 4, that is Data Protection Board of India. And one correction, in previous or two sessions previous to that, I have told, as it's an error, the number of chapters or total number of chapters in DPDP are 9. I told I think 6, and total number of sections are 44. Okay, that is a correction. That previous video I'm going to edit it and rectify. My apologies. Okay, let's proceed. So this section 16 talks about establishment of the board. As earlier informed, establishment of the board is mentioned in the act itself. That is why this board is a statutory body. It is not something the government is deciding to set up. It is other way around. The setting up the board is mentioned in the DPDP Act. Therefore the government has to ensure its establishment. Okay. So the government will set up the board through a notification in official gazette. Remember, official gazettes are the form of informing to the public. Any act or any communication will not be a communication regardless of the statements made by the respective ministry or the press releases. It is only become authentic and official only if it is released in the official gazetted document of the government of India. If it is a state related, it's a state gazetted. So that is one of the points we have to understand. So the composition of the board, as we already know, there should be a chairman and such number of members. I think it is around 6 members determined by the central government, and the selection is done by a selection committee. This selection committee will ensure the qualification. The members should have expertise in data governance, law, technology, governance or cybersecurity. Because why these fields are chosen? Because the data protection requires this kind of expertise, right? Because we are dealing with the data protection and its governance. So all these are related. So they need experts in these relevant fields. The term of office is kept for 2 years, and there is a term of office of the chairman is 2 years, and there is also eligibility for reappointment of the chairman after his tenure completes. Unlike other boards, we have seen minimum 3 years, but this 2 years is prescribed for the chairman of the DPBI, that is Data Protection Board of India. Okay, so there is also a removal clause they kept. So what are the grounds? Insolvency, as you know, a person who is unable to repay the debts is called insolvent or insolvency. That person is if he has assumed this kind of status, then he will be removed. And if he is already convicted for moral turpitude, it means that misconduct, unethical business, and for which he is already convicted. So even that reason comes to the knowledge of the board, the government. For that reason also he will be removed. Conflict of interest. So if his personal interest and as a member or the chairman of the board, if they are conflicting, he will be removed. Okay. Infirmity means incapacity, mental and physical. Let me erase. Mental and physical incapacity. He no longer able to perform. Under this condition also, the person, chairman or member of the board, will be removed. Or acquisition of conflicting financial interest. Okay. So suppose if the board is trying to punish a fiduciary for breach of data or obligations not fulfilled. If that member has a financial interest in that fiduciary, then it creates a conflict. So in those situations also it will be removed. So this is also very important aspect of the Data Protection Board of India, because we have so many boards or the tribunals like National Company Law or State Administrative Tribunal, which deals with the state employees, their salary or promotion or grade or those aspects, even Central Administrative Tribunal. So these are the tribunals or green law related to environment. All these tribunals, if you see them, they are mostly in person attendance for resolution. When they have a case filed to the tribunal, that these officers are in person most often, right? So the difference between the Data Protection Board of India and those is this will be going to be fully digital. Digital means the complainant and the and the body will be working on a digital platform. So no need to attend in person. Mostly no need to attend in-person hearings or submitting evidences, proceedings. All this will be done entirely through digital. So this is something very good for the in the light of the technologies and the speed at which the business and everything is happening. Speed matters, because other forms of in person involves a lot of inefficiency in terms of delays and post all these aspects are inherent in those systems. But here you find that speedy resolution of the issues. Okay, let's move on. Let's see the section 23, powers and functions of the board. See, the board functions like a civil court. So you know what civil court has powers, right? Inquire, receive, and inquire about the complaints, right, from data principal. Alleged breaches of the act. So the board can take cognizance of the breaches on its own without any complaint, or by reference by the central government. The Data Protection Board of India will act on its own or on the direction of the central government. It will take actions, right? If the data fiduciary has any, has not, has done any breaches, or they are not fulfill the obligations as per the act. Obligation in the sense, right? Safeguards, security safeguards, and several other provisions were not met. In that case, the board has a right to take action on its own. Just like court, the Data Protection Board of India can summon the persons to appear in person, or as we mentioned, board is totally going to be totally digital. They can summon the persons to appear through digital platforms and force them to produce the documents as required for the proceedings. Receive evidence on affidavits. So whatever you say, affidavit is nothing but, as most of you already know, whatever you say, you have to put it in the in a document and signed it. So it means that whatever you are, it's a kind of a taking oath. Whatever you are, the affidavit is signed by a notary. Whatever you are saying on the document is true to your knowledge. Since data protection is a kind of a technical subject, okay, it is about data processing, data protection. The board of Data Protection Board can seek assistance from experts like data scientists or cyber security, who are good in helping out the board in understanding the breaches or anything else. So these are the functions of a Data Protection Board of India. So there is also, just like our civil courts, to avoid the delay in the resolution, okay, it can refer to mediation. So that is nothing but alternate dispute resolution, if the parties agree. Okay, like data principal and data fiduciary, data principal and data fiduciary, if they agree to settle outside the Data Protection Board of India, even that provision is allowed. So this reduces cost and even faster resolutions. So we already dealt with the penalty powers. So it starts this 10,000. It is actually it is non-compliance by the data principal. See, data principal has certain duties. He has rights, but he has also certain duties, which we already dealt with that. If he breaches that, he is liable to pay 10,000. And if it's a data fiduciary, so the maximum for various obligations or breaches of the data principal's data, or on the non-compliance with the Data Protection Act, the maximum is 250 crores. So it is definitely a significant amount for a data fiduciary to be little vigilant about their obligations. So another aspect of the board is the board will decide if a certain fiduciary is non-compliance and repeated non-compliances, that fiduciary will be referred to central government to block it. Means its business will be stopped. So even that provision is kept, the penalty powers. Okay, let's move on. Okay, it's a very neatly depicted how a complaint flows, complaint to order. Complaint from a DP, data principal, against the data fiduciary to the DP against data fiduciary to Data Protection Board of India. Data Protection Board of, after hearing and after looking at all the evidences, it will issue order, penalty, directions, so many things. So let's, order is a kind of a against the data fiduciary. So let's see. Data principal files via, as we know, it is always, mostly it is through digital portal. Again, in the digital portal of the Data Protection Board of India, he files it. So physical visit not required. So this complaint, the board, Data Protection Board of India, will decide whether the complaint filed is maintainable, means can it entertain. So why it is saying it like that? Remember, we have discussed there could be several reasons. One, the primary reason is the DP always exhaust, always utilize available remedies. Then only you should approach the Data Protection Board of India. So first he has to approach the data fiduciary. If data fiduciary has done wrong, within data fiduciary there is a grievance mechanism. He has to utilize that first. Even after a grievance mechanism deals with the complaint, and if the data principal not happy with the resolution, then only DP can file the complaint to Data Protection of Bodies. So the key aspect is here, always exhaust the available remedies already provided in the Act. The moment the Data Protection Board finds that the DP has data principal has not availed or not approached the grievance mechanism, the complaint will be struck off, and it will ask him to go back to the DF and utilize that. That is one reason. Another, it also checks whether the complaint itself is genuine. Remember, duties of the DP, you should not file a frivolous complaint. Okay, so it will check that. So maintainability of the complaint will be decided by the board, Data Protection Board of India. So once it is maintained, let's assume it is maintainable, the board issues a notice to data fiduciary to submit its response to that complaint. Then in a normal process, as you see, inquiry, hearing will be done online or in person. Both options are available. And if there is a possibility of mediation, that DP and with if these two, data fiduciary and data principal, data appreciation understanding that they want to sort this issue between them through mediation, alternate dispute resolution, then the board will acknowledge that. Once the board, if it is not, let's say if it is not gone there and if it continues with the board finally passes an order, means decision of the resolution of the complaint filed by the DP. Reasoned order. What is reason means? Whatever the decisions it has made, like order 1, like under that sub things, you have to do this. It may be direct in the DP that you have found fault on XYZ. Data Protection Board of India found fault with the data fiduciary on XYZ obligations or XYZ things. It will mention all that for every for every item what it has mentioned. It will provide a reasons why it came to that decision. That is why it is called reasoned order. So it's not just that you have done wrong on this part or this one. It will not be, it's not like a unilateral. It has to explain how a DF has faulted. It has to provide, it has to give a decision. For the decision, it has to give the reason. So that is the reason I am trying to stress on the meaning of reasoned order. Even if you see the court judgments, if you see the entire judgment, right, for every decision made by the court, it will mention how it has arrived at the decision based on the evidences, based on the arguments and things. It will, so similar to that, a reasoned order will be passed. Okay, now that ends with the Data Protection Board of India. Suppose if the party, that is a DP or data fiduciary, not happy with the order or the decision of the Data Protection Board of India, they can appeal to Appellate Tribunal, that is already the existing tribunal which deal with the telecom, that is Telecom Dispute Settlement and Appellate Tribunal, that TDSAT. This is already existing one before the DPDP Act came into existence. So the government doesn't want to set up another appellate tribunals. They want to direct the issue, appeals to this existing board. It's a very wise decision, I believe, because it saves a lot of money for the tax money of the citizens. So it should be done within the 60 days of the passing of the board order. Okay, let's move to the next one. Okay, transfer of personal data outside India. So we will take a break here and we'll come back and discuss section 24 up to 26. Then we will, rest of the sections we will continue with next episodes, the following today. Okay, so let's take a pause, let's take a break and come back.